Hello, this is Rex Crandell, and the topic today is Advanced Healthcare Directives as part of estate planning. Estate planning has many different forms, but this is just one of the several that are needed for comprehensive estate plan. And the Advanced Healthcare Directive is designed specifically so that if you're unable to talk to your medical provider, you can have another person step in on your behalf. It's sometimes called a power of attorney for healthcare or advanced healthcare directive. According to a University of Pennsylvania study in July of 2017, 2 out of 3 people, adults in the United States, do not have an advanced healthcare directive. If you don't have an advanced healthcare directive and you have become mentally incompetent, it causes quite a bit of problems for your family. The person who takes care of you or makes the medical decision has different names. You might hear it as an agent, healthcare agent, health proxy, healthcare surrogate, representative, healthcare attorney in fact, or patient advocate. And if you become incapacitated and cannot talk, so hypothetically, let's say you got in a car accident and you hit your head and you could no longer talk, the doctors cannot act on your behalf because they have to get direction from some third party, and the doctors and hospitals are not allowed to make their own decisions on what you need without your consent or your representative. So what happens if you do not have an advanced healthcare directive and you become mentally incapacitated? You have to file a court case called a conservatorship, identify someone to be the conservator, and go through all the cost and time delay to get a conservatorship through the courts. It's a waste of time and money. So there was a case not long ago about Terry Schreibo. She had a heart attack, got brain damage because of lack of oxygen, and she was diagnosed to have a persistent vegetative state. Her husband and legal guardian or conservator wanted to have the life support removed, and her parents objected. And they filed lawsuits, and there were 7 years of litigation before they finally were able to remove her feeding tube. And they had 14 appeals. They had 5 federal cases. They appealed to the Supreme Court that was denied. So the problems of not having an advanced healthcare directive were horrendous in that case. So when you appoint somebody in writing to make your medical decisions, if you're unable, they can accept, refuse, evaluate, choose treatments or procedures. They can hire and fire healthcare providers. They can approve or disapprove diagnostics. They can approve the withdrawal of life support systems. And they also have the ability, with your permission, to donate organs. And this document, the Advanced Healthcare Directive, is revocable by yourself at any time. The way the document is activated, you make your decisions, and then you have appoint 3 alternate representatives. The first representative, if unable and unwilling to act, then you have a second one identified already, and a third. And that takes care of contingencies so that you don't run out of agents should you need them. And you need to decide whether you want the power of attorney to become effective now or only if you're mentally incapacitated. There's not really a downside to having it effective now because the doctors will still talk to you and follow your advice. And when picking someone to be your healthcare agent, you should make sure that the person will follow your written instructions. If they have strong views on, say, right to life or not removing a feeding tube, if that's what you want, that's not a good person for your agent. And in an Advanced Healthcare Directive, there's also the right for post-death authority for them to donate organs, take care of funerals, burials, those types of things. And in your healthcare directive, you can nominate someone. If you need a court supervised conservatorship, your nominee can be listed. Your end of life decisions should be indicated so that there's no question for your agent and medical personnel whether or not to prolong life with a feeding tube or not, or when the circumstances you would want to terminate your life if there was no life ability to recover. Another part of the Advanced Healthcare Directive is they call it palliative and hospice care. That's pain, whether you don't want to have drugs, do want to have drugs, don't want to feel anything. And the other wishes, you can put any kind of wishes that you want that are legal for the agent to request. For example, if you want your cremated ashes scattered at sea, or you want to be buried with a predeceased spouse, that's all within the rights of the Advanced Healthcare Directive. And you could also consider organ donation. Most of my clients say, oh, all my organs are worn out anyway, nobody would want them. Well, that's not really true. You know, talk about transplant use for therapy, research, or education, organ donation. Your directive can also identify your primary physician and secondary physician. I don't recommend doing that because I think my view is that you should allow your agent to hire and fire medical facilities based on what your particular needs are. This document is, you put in there that it's a copy is as good as an original, so you don't have to deal with the originals all the time. And to make the document active in the state is you need 2 witnesses or notary. I always notarize the Advanced Healthcare Directives because I want no question that the person was the person that signed the document. If the patient is in a skilled nursing facility right now, then there's a person called an ombudsman, and that ombudsman would have to approve the Advanced Healthcare Directive. So some of the things you want to consider, if you want CPR, mechanical ventilation, feeding tube, dialysis, antibiotics, antiviral, hospice palliative care, organ and tissue donation. And as a separate document, there's one called a physician's order for life-sustaining treatment. It's different, and that's included under do not resuscitate orders or do not incubate orders. It is a separate document from the Advanced Healthcare Directive. Once you have an Advanced Healthcare Directive, where do you put it? Well, you should keep the originals in a safe place. Give a copy to your doctor medical provider so they can use it and contact the person that is your agent. You should keep a copy and give one to your agents and family members. Another good idea is you put a wallet size card in your wallet stating that you have an Advanced Healthcare Directive and how to contact the person that you've appointed. Another thing I always suggest is putting a copy of it in your estate planning binder. Now, it is recommended that you update your Advanced Healthcare Directive every 10 years so that you can keep up with the changing medical conditions. Where can you get an advanced healthcare directive? Well, it's my recommendation, and I'm sure I'm biased, is that your estate planning attorney who's knowledgeable in the law and the various aspects of it would be able to help guide you through your wishes and final decisions. I do not recommend these website vending machines where you put money in for a form and it comes out, because there's nothing in there that it's all standard. Good for everybody may not be good for you in particular. So I hope that I haven't given you too much information today about advanced healthcare directives, but it is an important subject and it is part of a comprehensive estate plan. And I would like to conclude now with a statement from Mahatma Gandhi, and that is, the future depends on what we do in the present.